All right, guys, what's going on? Today is Thursday, February 22nd, and we are starting our legendary webinar. You guys been waiting all your life. Okay, I know you've been waiting for this all your life, and some of you have been waiting since 2015, some of you from 2016, 17, and whatever, depending on when your EB-2 was approved. Okay, and of course, you know what I'm talking about. And uh, I decided to make this webinar for you guys who are most likely a citizen of India or was born in India, who is in the United States on H-1B visa with EB-2 approved with perm certification, with labor certification back in the day. And of course, the priority dates for Indians, Chinese, and other nationals are through the roof. Okay, right now, 12, maybe 14 years, and it doesn't seem like this number is gonna shrink anytime soon. Okay, so if you are in this position and you have to extend your H-1B visa indefinitely, that means that you are pretty miserable person because you don't know when things are gonna happen and you want your green card. And I have a recipe for you guys. I have the solution, and that's what this webinar is about. Okay, so let's go straight to the topic. I do believe that we will be able to get things done within an hour. Okay, at least I will be trying to get it done within an hour. However, if we have to stay a little bit longer, of course, I'm willing to spend a little bit more time with you guys. Okay, so what you will learn today, and I kind of mentioned the main thing that you will learn. However, there will be a bunch of things that you will refresh your recollections, or you will probably never heard before. So we will be talking about the quota and limitations for EB-2 and EB-3 visas. And of course, many of you checking the visa bulletin every month because your life basically depends on this. And you pretty much know what is the final action date, what's the date for filing, what's the final action date for Indians, and things like that. But we're gonna refresh this. Of course, you will know how to get your green card probably within a year, especially if your priority date is before 2020. Okay, before 2020. And I know that most of you have the priority date before the 2020, but even if it's after, it's still gonna speed up your process immensely. Okay, that's gonna speed up really big. Okay, and of course we'll be talking about strategies, how to expedite your visa application to get your green card probably the end of 2024 if you start now, maybe in 2025 in the beginning of that year. Okay, let's move on. Of course, you guys know that when you stay till the end of the webinar, you will be able to get the gifts from me. And I prepared 2 gifts for you. Gift number 1, you will be able to get a free evaluation of your case. And of course, you know that that case will be EB-1A. Okay, the free evaluation for your EB-1As. And gift number 2 would be the guide on how to get a US talent visa. And guys, believe me, that guide is unique. Okay, I developed it myself, and of course, I want to make sure that you get both gifts, because the combination of both of these gifts will give you the result on top of being here and listening to this material. All right, so stay tuned for the gifts. And of course, what I recommend is to focus on this webinar because like your life depends on it, and we know it does, right? So take notes. Of course, try to isolate yourself from your family, from your colleagues, so you could focus on my voice. I promise I'm not going to hypnotize you. I'm just going to give you the good stuff and understanding how you can get your green card very, very soon, much faster than you expected before. Okay, so make sure you focus and you take notes. Who is this talented, beautiful person, this seasoned attorney who brought more than 2,500 people here in the US from over 50 countries? Of course, this is Stanislav Shamaev. Okay, who is Stanislav Shamaev? A business, immigration, and corporate attorney. Okay, I'm the founder and leading attorney in Shamaev Business Law, the company located here in Miami. Our headquarters in Miami. We have more than 100 employees across the world, and I'm also a member of Florida State Bar Association, Broward County Bar Association. I may practice law in Florida Courts of Appeals and 11th Federal District Court of Appeals. Okay, those are the big appellate institutions. And also I can practice immigration law in all 50 states and all territories, regardless if you guys in New York and California, in Texas, and many of you are out there, I can help you out being here in Florida. Okay, why? Because immigration law is federal and it doesn't really matter where you're located, which bar association got you the bar license. We can help you if you are whenever. All right, and of course, I'm a member of AILA, which is great. And guys, my corporation, my teams, and everybody who works for my company, we're all focused on 3 types of visas. And those are business and investor visas, the talent visas, and work visas, okay? And sometimes I say it a little bit differently, but it doesn't change the fact that we specialize only at those visas you can see on the screen. All right, so we don't take deportation cases, we don't take family cases, we don't take asylum cases. If we get those, we refer to other attorneys, but we are specializing and we have deep knowledge in this type of immigration. And of course, the highlight of today's webinar is EB-1A. Okay, EB-1A is the one that we are focusing on today because we have a very narrow situation when this visa is the most appropriate. Okay, all right, so let's move on. All right, so the main question today is how H-1B holders with approved EB-2, EB-3 visas can secure a green card within a year. Okay, basically defying visa quotas. And absolutely, that's the way to go. We are going to be talking about mostly those countries that are in the list of visas with high quotas. Okay, with the long lines, long queues to get the priority dates. And as I said before, India is one of those countries because there's a huge backlog for Indians who got approved for EB-2 category, including EB-2 and a W. Okay. All right. So, what is H-1B visa? And of course, I assume many of you guys are holders of H-1B visa, and basically you don't need a deep explanation what H-1B visa is. Okay, we don't really need that because you are the ones who hold those visas. But let's assume there are people with other nationalities for this webinar who either want to get H-1B visa or are currently holders, and you want to explore your options how to switch to other type of visas. So to get H-1B visa, we need education. Okay, we need a higher education, at least a bachelor's in certain professions. So not all bachelor degrees they're treated the same. Of course, we need an employer. Okay, and we basically need a waiver of a perm. Okay, it's like or it could be a waiver, or sometimes I call it a perm light. Okay, because we don't have to go through the labor certification process, because the professions that are in the list for H-1B, they are deemed to have shortage in the US. So basically, there is no need to go through the labor certification. We can get a waiver of it, or get a light version of labor certification. And last but not least whatsoever is to be selected in H-1B lottery. Okay, and the lottery is going to begin in a couple of weeks in March. It's going to go for 2-3 weeks, and at the end of March we will be able to know who has been selected. All right, and once we're selected, we'll file a form I-129. We get it approved. Starting July 1st, it's possible to schedule interview in the embassy, and September 1st is the first time when we can enter the country, and October 1st is the first time we can start working in the USA. And H-1B has a limit of 6 years, two terms by 3 years, which makes it 6. And if we have, during our stay on H-1B, approved EB-2 or EB-3 visas, then we can extend H-1B indefinitely while that green card is pending, basically while the priority date is pending. So, and everything is great, no problem. We can travel, we can work, we can attach to one employer, we can change the employer. It doesn't bring a lot of damage. But if you have EB-2 approved with the current employer, I guess you're not gonna change that employer, because they can withdraw, and things are gonna change. So you're kind of stuck on the boat. Okay, I don't want to call it a slave on the boat, but it's kind of, the concept is the same. So that's what's going on with the H-1Bs, and I guess the biggest negative thing in H-1B is that your spouses have H-4 and they cannot work. Okay, and some of you have the kids who start aging out, getting close to 21 years old, and this is a huge factor of the weight. Okay, because if your priority date for EB-2, let's say 2017, all right, and your priority date is going to be probably realized around 2030, and your kids are 17 right now, I mean, the chances are they're going to be out of the age at the time when things going to happen. Okay, so that gives you a lot of stress. That would give me a lot of stress. So 3 factors. You stuck with one employer, your spouse cannot work, and your kids may age out at the time of the green card. Okay, and of course the wait time. The 4th one is the wait. You have to wait till things happen. And even the 5th one, the factor of unknown. Okay, because that 12 years of wait may change to 15 years. Okay, overnight. Like this new visa bulletin may come out for March 2024, and we may see the drop like 2 years behind. Okay, I mean, that happened before many times, and you guys know it. So it's not the best way to stay and wait, but there are options. So, and I'm kind of want you to give you the solution right away, guys. I don't want to hold you back. Like, oh my God, I kind of already told you the recipe, the winning recipe for those of you who are in this situation, and that is to get the case for EB-1A. All right. So now let's talk about what what's the solution? What's the technicalities of the solution? And this is very important to understand, because if you don't, then you're kind of scared to move on with this solution. But I will give you the breakdown of what's going to happen. So again, let's repeat the situation that you guys facing right now. You're from most likely from India, maybe from China. You are in the US on H-1B visa, and you have the EB-2 approved for the same employer, and your priority date is, Lord knows, maybe anywhere from 2010, maybe 2012 to 2024. Okay, so that's where your priority dates could be, and you want to get your green card as soon as possible. So what does the law say if we get you approved for EB-1A, the talent visa, extraordinary person? And I know, guys, many of you like, oh my God, Stanislav, I have no talents, I'm not extraordinary, I'm just a good professional. But hear me out, guys, hear me out and stay till the end, because I'll be able to prove you that the majority of you do qualify for EB-1A visa. And I know it because I've done so many of them, hundreds upon hundreds. So once we get your case going for EB-1A and we file it in about 6 months from the time when we started working on your case, and that's when we're going to get the new priority date. So let's say it's going to be September 2024. And let's say your priority date for your EB-2 is October 2019. All right, just hypothetically, but use any date. So what I will be able to do for you guys is to request the USCIS to transfer your older priority date from I-140 for EB-2 to your newer EB-1A I-140. All right, so basically, yes, we're going to have the priority date for September 2024, but it's going to be substituted to October 2019, as if you filed your EB-1 case back then. All right, so like you guys jump on the time machine, like go back in time and file your EB-1A instead of EB-2. All right, and once we get that done, and this is it's a relatively fast process. Once we get that done, automatically your new priority date goes into current mode, and then we can file the adjustment of status for you, for your spouse, and for your kids. Okay, very important to understand, guys, that little moment switching between two priority dates, that's the deal breaker in all of your cases, because that way we remove all these years of wait in the future. And let's say in this hypo, where your first priority date is October 2019, your estimated time when you're going to get your green card is going to be October 2029 plus 12 years, right? Oh no, October 2031. So 2019 plus 12, October 2031, which is like what, 7 years from today, right? Maybe even more, 7.5. By doing this process, switching to EB-1A, working on your case, getting it approved, requesting the older priority date substitution, you will be able to file 485s for your whole family, probably end of 2024, maybe at the beginning of 2025. Okay, so that's the mechanics of this process. That's how things are going to go, and that's the way we have the cases going for our Indian clients. All right, and guys, I didn't cover the what EB-1 visa allows you. Why? Because you know what it allows you to get a green card and then to switch to the American passport, and that's the ultimate purpose for all of us. So now, let me remove all your fears that you will not be able to get your EB-1A approved. Okay? And guys, I have so many Indian clients right now who are in this same position with H-1B, EB-2 approved a few years ago, and they're desperate to get the green cards, and we're working on the cases. And guys, for those of you who are in the same position, the overwhelming majority of you do have the base case for EB-1A, and I will tell you and explain why this is the case. So let's remind ourselves, what is EB-1A? EB-1A visa is a visa for extraordinary people in their profession, okay? And I know that extraordinary, the word extraordinary kind of sounds a little bit daunting, like, oh, I'm not extraordinary, like, I don't know how. But from the point of view of immigration services, they have a measure of who is talented or who is not, okay? This is not some kind of fiction where we're like, okay, how do we measure the talent? We have the exact measurement, and that measurement is the criteria, okay? There are 10 criteria in EB-1A. For our purposes, we're going to cover only 8 out of the 10 because most of you are in the STEM category. You're engineers, you're IT people, you're data analysts, you're cybersecurity, you're blockchain specialists, you're math. You have to do something with math or with the science and things like that. Or you are the one who in managerial or executive positions. Okay, yes, it's not STEM, but it's very close to it. The analysis is pretty much the same. But regardless, you could have any profession. All of them fit within EB-1A. So we need to satisfy at least 3 criteria to get approval for this type of visa. Okay, so out of the 8 criteria, we need at least 3. But Stanislav likes when we have at least 5 to 6 criteria. Why? Because there is a subjective element to assessing each separate criterion. And let's say subjectively the immigration officer did not like a certain criterion and he did not accept it. So if we file only 3 criteria, the minimum number of criteria, this could be a problem because then we're facing the denial. But if we file 5, 6 or more, sometimes we file 7, sometimes even 8, then if we get the subjective denial of 2, maybe even 3 criteria, we still have the rest standing. Okay, and that's how we're going to get you approved. So let's now talk about the concept why you guys either have a base case for EB-1A or you may work on your case for another 6 months and get it to the level of approval. And it's going to be pure logic. Okay, it's not going to be a legal talk. It's a pure logic. So many of you, if not all of you, work in really good companies. Okay, it could be like I just had a guy who works in Nike. Some of you work for Amazon. Some of you work for Google or other smaller companies. And why you by definition already have at least 1 criterion satisfied, and the criterion is a critical leading role. This is the 4th one on the screen you guys see in the presentation, because all of these companies who use H-1B program, they're all the companies with distinguished reputation. Okay, and usually it's a bigger company, it's a more famous company. Rarely I see H-1B visas for companies that are not known or like this really small. It happens, but even in those cases, usually those companies work with bigger companies, and that way we can establish the reputation. And all of you worked for a long time in the States, and you did play a critical or leading role in those companies. Okay, so all of you at least have 1 criterion as of now. Okay, leading or critical role. So you did something good for the company, and we can get it done by means of getting the letters of support from these companies. Okay, so and I'm not going to go in a let's put it this way, chronological or a logical way of the EB-1A requirements, I would be going the way that you guys see more fit to your cases. Okay, so that's why we started with critical leading role. So this is number one. Number two, let me switch, your commercial success, the eighth one on the screen. Most of you, if not all of you, do have commercial success because you worked so long in this company, or your position is such great in the company that your salary is beyond the average what the professionals get in this industry. And when you are located in the US and work for a certain time, we're definitely going to measure by the US standards, but those cases that I see, you guys all above at least 20 to 30% above the average salary for the same professional in the same geographical location. Very important, okay? Not in the US, not in the state, in the particular town or city, all right? And we can find out this really easy. There is a statistics by all the professions, by all geographical locations. And a lot of you make 180, 190, 200, 170, and the average in the profession would be, and again, depending on the profession, it could be anywhere from 90 to 130. Okay, so if you make above 130, 20-30% more, you will satisfy the second criterion, the commercial success. And guys, voila, we already 2 criteria in, and just 2 minutes ago you thought that you didn't satisfy even one of them. Okay, so let's move on. But let's see the question from YouTube. And of course, those of you guys who watch me on live storm, you have the advantage of asking me the question directly on live storm. But of course, we will be looking what's happening at YouTube. So Krasav Pen. As I was born in India, even if I become a citizen of another country, say UK, do I still have to wait for a very long time as much as anyone with Indian passport? Absolutely, absolutely. Very good question. So USCIS is looking at these things as not by the passport, okay, not the current citizenship. And trust me, guys, those Indian clients that I have, a lot of you have Canadian passports, UK passports, some of you have European passports or some other countries, but it doesn't matter. For the purpose of today's discussion and visibility and the priority dates, they are looking at the country of your birth. Okay, the country of your birth. So having a second citizenship or a new citizenship does not remove those limits that we will have while filing for EB-2. Okay, and of course EB-2 is one of the most popular visas switching from H-1B. Ricardo, is your suggestion porting your PD to EB-1? Okay, PD is priority date. Absolutely, Ricardo, you got it. You got it. Ricardo Foster. Ricardo, it doesn't, like, your name doesn't seem like as if you're from India, right? But if you're from the country that has also some limitations, or even you're in a country that has no limitations for EB-2, but you have EB-2 approved, let's say 2 years ago, and you still have to wait. Okay, or like a year ago, and you have to, and you don't want to wait. I guess this situation is not as tense as with Indians, right? Because Indians have to wait for 12 years, maybe even more. But yeah, we can still use the same tactics. So basically, you use the word porting, like I would say teleporting. Okay, teleporting the priority date from your EB-2 or EB-3 to EB-1. Okay, and basically substituting. But again, like EB-1A is current for most of the countries, so I don't see that technique applicable to most of the countries. Only to India and China. That's when it makes a lot of sense, and I think Mexico and Philippines as well. By the way, maybe you're from Mexico, right? So maybe that's then something that you want to look at. Dexpel, hi Stan, hope you're well. Thanks for this webinar. If you have an H-1B from reputable, or if you're MD and you get residency from hospital, can they jump the lottery and issue visa to employee abroad? Okay, so let's see. So Dexpel, I guess your question is I guess your question is I'm not sure, Dexpel. I'm not sure if I'm because I have like a few interpretations of your question. So if you follow up on this, I would be more prepared to answer. Dania, then I have approved EB-2 and IW, and I'm on O1. Okay, very good. My spouse is O3. Adjustment of status is due a year. My spouse wants to start her residency in hospital. Please guide me what to do. Don't want to go for H-1B. Can DAT help? DAT. What's the DAT, Dania? I'm not sure the meaning of that term. So let me Google it real quick so we could move on. Okay, so DAT meaning. Let's see. Yeah, there's a bunch of guys. Give me a better, because I don't know what DAT means. So, but let's talk about this situation. So, if your AOS is due a year. I mean, and she has the residency right now. There is no straightforward answer to this. Either maybe she get a J1 visa, Dania. J1 visa is probably the answer to this. So I don't do J1s, but look into J1 and maybe M1. Okay, J1 and M1 visas that may help. Dexpel, for EB1 or 2, if we claim 5 criteria, will officer see 3 and say okay, approved, or will he ensure that all 5 claimed have to meet? I heard that sometimes a half-cooked criteria can be kind of can be useful for your profile. So nobody knows, but I have my view on this, Dexpel. I have my view. So for EB1A, definitely he is going to look at all your criteria. Yes, he can get to 3 and say, okay, objectively it's good. But remember, EB1A gets 3 stages of analysis: objective, subjective, and benefit to the US. Okay, what's objective? 3 criteria. Okay, like we're discussing right now: critical leading role, commercial success. We're going to discuss others. Okay, so once he gets to 3, he says, okay, objectively we're good. Let's move on to the subjective, and that's overall merits. And overall merits, he needs to look at all the criteria that we claimed and everything else that we have, and see if we're really at the top of the field. Okay, at the top of the field. So kind of 3 is enough, but we need like 6 to not only maybe substitute the weaker criteria, but also for the overall merits, for the subjective part. And then once he's like, okay, you're like at the top of the field, let's see if you can benefit the US. And most of you guys have an employer who are an H-1B, so having an employer giving a job offer for the purpose of a P1A, why he would not do this, I don't know, because we already have EB-2 approved. So that removes the third one. Kind of, we're already going to benefit the US through working in a company. So that's EB1A. EB-2 and IW is a little different because, and I'm not talking about the exceptional ability in EB-2 and IW. That's when we don't have enough education, right? We need to start with the exceptional ability and then talk about the project and things like that. I'm talking about all the criteria that we need to cover in EB-2 and IW. And here we don't have a choice. We need to satisfy all of them. Okay, we cannot choose, okay, education, well positioned, and national importance. No, we need to cover all the criteria. So that's why EB-2 and IW is so much more, a lot more subjective, because each criterion has a subjective assessment, then all of the criteria has the subjective assessment, and particular things like national importance, subjective. I think there is national importance. This officer thinks there is not. The third officer thinks there is. So it's all very subjective. That's why we need to put a lot of pressure on that. All right. So let's see what else. Treasure. If we on O1 using adjustment, will we have to go back to home country to stamp? Or can we stay easily in the US and carry on with our life? Yes, treasure. So the proper word is not the adjustment, but the change of status. Okay, AOS, adjustment of status, is only when we change the non-immigrant to the immigrant. When we change from non-immigrant to non-immigrant, this is COC. Change of COS, change of status. Okay, so yeah, you don't have to leave the US if you switch to O1, but if you plan to travel, once you get out of the country, you need to stamp your passport. Okay, you need to stop by the embassy and get it stamped. If you stay in the US, no problem, you just change your status and you're all good. Christina Romanescu, how can I get the EB-1A visa? Okay, that's what we're talking about today. Ashish Verma, if my company is starting to apply for EB-2 with perm, should I let them apply? Absolutely, absolutely, Ashish. I mean, it's not going to hurt anyone. It's not going to hurt. I mean, if you planning to get EB-1A faster, it's going to change things, but you know, I would never say no to this process. I have 18 months remaining for H-1B, 60-year limit. It's a little tight, very tight on time. They need to really speed it up because 18 months is like really pushing the limits. Or should I go with self EB-1A or EB-2 and IW to extend H-1B next year? Yes, you can go with EB-2 and IW for the purpose if you want to stop the clock ticking. Okay, that could be the case. And most of you guys from India have really good EB-2 and IW cases. But if you have a good EB-1A case, I would just focus on that. I just focus on that. And of course, to know if you have a good case or not, you need to get a free evaluation from me. And at the end of this webinar, I will let you guys know how you can get that. Okay, so let's do the last question, and let's go back to the materials, because I will leave maybe 10 minutes at the end to go back and see your questions, guys. Dexpel, regarding H-1B, I want to ask that if someone gets a job, then does he have to wait for lottery, which can take a lot of time? Yes, absolutely, Dexpel. So I guess your question is, so you are in the US, let's say on O1 visa, and you get some employer who is willing to sponsor you for H-1B. I don't see why would you go from O1 to change to H-1B visa when you can just switch, you can refile your O1 to, let's say, to this new employer, okay? And you get another 3 years of status, and then just extending it by year. If there is no O1 visa, let's say you're on F1 or OPT, and there is a H-1B opportunity, but you don't have the lottery, you have to go to the lottery. Okay, there is no such a way to go to the H-1B without a lottery, unless they do the Schedule A reform, and you guys, you know, I just came back from New Orleans from the conference, and where these things were discussed, and there was the representative of USCIS, and he said that yes, this thing with Schedule A, and again, I'm not gonna go deep what Schedule A is, but you guys know what I'm talking about. So basically, what they want to do is to a lot of things. I don't know if all of them will happen, to remove the perm certification for Schedule A, or even remove the lottery for H-1B. I don't think that's going to happen, but removing the labor certification sounds pretty reasonable to me. Okay, like Schedule A professions, like the professions are in most demand. Like hands down, there is no less shortage. There is no people. Okay, so yeah. But there is no such a thing yet as as H-1B without lottery. Okay, so guys, we stopped at 2 criteria. All of you have critical leading role, and most of you, if not all, have commercial success. Now, let's talk about judging the work of others. And this is the 5th one. And remember, 1, 2, 3, 4, 5, judging the work of others. So either you, as a classic example, go to some competition as an expert and you assess those participants and you decide who's going to win or not. That's the classic judging. But guys, don't forget that if within your company you are being asked to assess the work of other professionals in your field. So if you're an engineer, if you're a scientist, if you're an IT person, architect, designer, whatever. If you're even assigned a task within your company to assess and review the work of other people who are also professionals like you, this is also judging. Okay? This is also judging. So don't sleep on that, all right? Because I know most of you just hard work, and I know you guys hard working. And that's why this webinar is for you, because there would not be this webinar if you didn't work hard in your position. So go back in the past from all the companies you worked before. And remember, if you had to do the assessment, review of other employees, other professionals, and make sure that you are looking at the hard skills, so they professional skills, not their soft skills. Okay, I mean, it could be a part of it, but we're looking at the professional things, what they can do, the quality of their work, and things like that. Okay, so, and voila, many of you already have 3 criteria. Okay, 3 criteria, which is really good. It's a good start. Now, contribution in the industry, the 6th one in the order, but the 4th one in the logical approach. So, a lot of the companies you guys work for, Amazon, Google, Facebook, and all other those big companies that give a lot of H-1B opportunities, the product that those companies release or prepare, or the software, or the applications, they go beyond the company. So basically, other companies and consumers in the industry use those products. And a lot of you participate in developing, in coding those products, in marketing them, in pushing them on the market, in analysis, whatever you guys do. If you've done things like that in the past, for those products in the companies that you worked for or you are working for right now, guys, this is a contribution in the industry. Okay, don't be shy. Remember all the products you work for and see if they went beyond the company. So not only used for the company's purposes, but they are used for the consumers or for other companies, B2B. Okay, or B2C, or whatever that is. Okay, for example, you worked in AWS for the cloud services. Okay, and you created the cybersecurity protection for the services. This is a contribution in the industry because it's innovative and it's significant because a lot of people in the world using those services. So cybersecurity of those services is critical to the whole thing. to the whole industry. Okay, so many of you work on products like this, hands down, and I know it because I have 5-7 complex immigration plannings a week with people from this category: H-1B from India or China, EB-2 approved and ready for EB-1A. Okay, almost all of you have contribution in industry. And there you go, guys. This is the fourth criteria. We're already above 3, but we're still below 6. Okay, so Stanislav, where are the other 2? And I'm going to answer this question. The first one is number 3, the published articles. The published articles in scientific or academic magazines or outlets. Okay, and some of you already have that. All right, some of you drafted some articles in your master's degree, some of you maybe in PhD, and by the way, PhD is a great thing for any type of visa. Okay, if anyone have PhD, guys, I'll get you a green card. But again, published articles, how many, Stanislav? How many articles do I need? Well, at least anywhere between 3 to 4. Okay, all right, plus. Okay, so guys, anywhere between 3 to 4, meaning 3 or 4, and plus, and more. If you give me 5, 6, very good. Stanislav, my articles were released 10 years ago when I went to school. No problem, no problem. As long as they are in the same industry, we can count them in and use them as the 5th criterion in your EB-1A case, in your future EB-1A case. If you do not have published articles, this is not a problem, because within 6 months of working on your petition, you will be able to draft those articles and get them published. And as long as you have the material or ideas, these things will happen. How? We have our partners who help our clients to speed up this process. Okay, speed up this process. The process of drafting, the getting the materials ready, and the process of getting it published in professional magazines, journals, and things like that. Okay, so this thing is going to get done. So, and that is the 5th criterion. Now, and some of you already celebrating, guys, right? Like, oh my God! And if you look at this 4th leading or critical role, you see this guy in the middle with a star about his head or her head, and pow! So that's you right now, guys. Like, oh my God, I didn't know. I'm already like 5, maybe 4 criteria in, and that's good. Okay, and the last one, and again, last one within the format of 6 criteria that I want. Okay, I want 6. So the media coverage. Okay, a coverage of your work and your achievement. And media could be in the US, it could be in India, it could be in Mexico, it could be in China, depending where your country is. And again, you work with the PR agencies. We have all the contacts of those companies, international companies that help our clients to get the media coverage. It's no brainer, guys. And all of you have the materials that will make journalists excited, because you know those are like things in it, the science and technical things and innovations and things you work on. They're very exciting, and they're very exciting for the readers and for the journalists. So you will get like about 4 articles about you in the media. And that's how we get you to 6 criteria. And let me tell you, guys, if we do all this that we're discussing right now, if you're ready to do all this, and I don't see, there's 0 reasons why you don't want to do this, okay? Because you just don't have any other options. That's it. It's not whether you want or you don't want. It's whether you're going to be doing this or not you're going to be doing this, all right? Because there's no other option. All this is going to be done within the next 6 months of working on your petitions. And of course, some of you have awards, And some of you have awards within the companies. We can make arguments on that. Some of you have larger awards like in hackathons or other competitions, startups and innovations and incubators and accelerators and whatever that is. We can count that as a seventh criterion, and that happens quite often. Some of you speak at the conferences and your thesis is being published. So, or you get some kind of award of the best speech of something like this, or whatever, something standing you out of other speakers. We can use that as award as well. All right, and that is the seventh one. And of course, as professional associations, not too many of them qualify for immigration purposes, but sometimes I see the professional associations that have some levels, some hierarchy within the organization, which gives more flexibility for us to deem those higher status within the organization as what we want for the immigration purposes. Okay, so let's say there is IAAA for IT people, for IT specialists, and the common membership doesn't fit. But starting with a senior, they have senior, fellow, and like a life member. Life member is like you have to be like really like Oscar winner or something like this in the IT world. Fellow is very hard, possible. Senior is hard, but definitely possible. Okay, and we get our people in this organization from time to time, and it's subjective whether an immigration office is going to deem that a good thing, but it always looks good on the petition for the IT people. All right, so guys, now you see that you can do your EB-1A case within the next 6 months, because for most of you, the only addition to the case is articles and media coverage, which is easy and fast. So the question is whether you start yesterday or today. Okay, that's the question that you have to ask yourself and get an answer. Okay, recommendation letters and expert opinion letters. And a lot of you have no problems providing up to 15 recommendation expert opinion letters on your case among your colleagues, ex-colleagues, people you meet at conferences, people you know from LinkedIn, you're just friends who are in the same field, and you go drink a beer at the bar. So they will be the one drafting those letters. But guys, you have to remember that in my company, there is a program that's called NEO, N-E-O. And that's the program where within the company, we can get you up to 4 expert opinion letters among other clients within the company. Okay, and you can't exchange. It's not that you get them, you exchange with them the expert opinion letters. Why these letters have a lot of weight? Because of the name of it, guys. Just look at it. Expert, so somebody who is expert, and that person is going to be also probably going for EB-1A or EB-2 in IW. So all these people are experts. Opinion, okay? Opinion. And opinion is objective opinion, okay? Why? Because that person doesn't know you, and you don't know that person. So whatever they assess, whatever assessment they make in your criteria or your case is going to be objective, because they don't have any emotional connection with you. They just look at the papers. And of course, such a letter with the independent expert opinion letter, okay? That's the name of it. Is going to have a lot of weight for the officer, and he cannot substitute the independent expert opinion letter with his own opinion without hard evidence. And I mean, when you write a letter like this on like a contribution in the industry, or judging or awards, I mean, no officer can say, hey, I just don't believe this expert, because that's illegal. You cannot do this. So imagine the weight of those letters that we can get you within the company. And believe me, within the STEM industry, we always have people with a similar professions. Okay, so recommendation letters already covered. So about 15 of them, and we can help you with this process. Guys, you have to follow me on Instagram because I put a lot of good content there. Here are the cases that some just interesting cases for you for EB-1A, but to be honest with you, I want you to give you better cases, better pool of recent approvals from STEM category, because STEM or business, because that's what you are. Most of you, either business or STEM. Okay, and yes, crypto analyst is kind of a STEM case, which was probably the first case in history of immigration services where the crypto analyst was able to get an approval for this program. And guys, very hard case, very innovative, very challenging. We got an RFE, we got it approved. Okay, so it was very hard, but it was a good case. The precision shooter guy from Kazakhstan, also through RFE, we got him approved. Kind of fun case. I put it here just to entertain you, but again, so I think STEM cases are more relevant to you. So follow me on Instagram if you have not yet. I will be giving you more examples of STEM cases for EB-1A, so it's closer to you. All right. Okay. All right, let's talk about presents and then let's get back to your questions. So you guys can always contact my company through WhatsApp. You can either scan the QR code or make a screenshot and ask any type of question you have about today's material and everything else you want to know. And now, gift number one for those of you who have not gone through this procedure, and that's how you guys make your first step towards the either immigration to the US or switching your H-1B to EB-1A. So I suggest you guys focus on EB-1A QR code, scan it, or make a screenshot and scan it from a different device, and that's how you're gonna get a free evaluation from myself. Okay, how it's gonna work? You're gonna answer me a bunch of questions, spend a little bit time, give me as many details as possible. I will take 2 days to analyze your petition and come back to you and let you know which program is good for you, which criteria we satisfy, which we don't satisfy yet, and if you have a potential in your case. What is the potential? Potential means that within the next 6 months we can improve on your petition, file it and get you approved with chances 90-95% when you fulfill my strategy working with my team. If you do have the potential, then I will invite you to the complex immigration planning, where we'll be discussing the strategy of implementing your EB-1A case. But also, don't miss EB-2 and IW, and maybe some of you want to get the O1 visas. Also, those of you who stayed till the end and registered for Livestorm webinar, you will get an email with the links to get the free evaluation. And also, the guide that I mentioned to you in the beginning, the guide for talent visas, okay? In-depth analysis of each criterion and whether you qualify or not, okay? So make sure you scan the QR code or you make a screenshot and then download this guide, and make sure you do it now, because in a couple of days that link is not going to be available. Okay, because that's the gift for you guys who are present at this webinar. All right, so let's go over the questions and see what you guys have cooking. And also don't forget to follow me on all these platforms, because I post the exclusive materials on all of them. All right, so where did we stop? Ashish, I think your question was last. Oh no, I got it covered. Dania, referring to my question, I meant if we apply for I-76 authorization for my spouse, can she work on that, or G1 is the only way? So you, Dania, I remember your question. So you said that your priority date like is a year to go, unless your priority date is in, or it's a date of filing date, and USCIS allowed to file for using the date for filing table, then only then you can file for 485, including 765, to get your spouse the work permit. Okay, otherwise I don't see how that's going to happen. So I would still see if that company, that business is willing to file for J1 or M1 visa and get that gap covered, the year gap, right? So after that, but watch for J1 2-year how do you call it, limitation, 2-year limitation, because some J1s, once you get that, you kind of say that 2 years after I finish my work, I'm not gonna file for any immigrant visas, okay, a non-immigrant. So make sure that it's either not there, so there are different types of J1s, or if it's there, be ready to file the waiver for this type of visa. Ashish, I have heard last month news about India getting added to the treaty countries list. It will be very exciting for Indians to get into treaty visa, switching from H-1B. Yes, Ashish, if that happens, oh my God, the floodgate is gonna open. I'm, to be honest, never heard of the rumors like this, and at the conferences, no one spoke about India, neither the attorneys nor the USCIS representatives. Never heard about that. But if it's the case, I mean, I'll be happy for you guys, because E2 will give you more flexibility as to that craziness that's happening. Cross-South Pen, if we take your services for EB-1, would you also connect us with the media houses for publicity? Absolutely, guys. We give you all the resources. So basically, those criteria that needs to get some work on, the media, the scientific publications. If you have to write a book, or you want to look for the competitions where you could participate and maybe win if you're good enough, or where you could be a juror, we give you those resources, and it's a part of the services we provide you, to connecting you to those companies that can help you. Okay, so of course. Ashish, by when should we get the guide for talent visa? What do you mean, Ashish? What do you mean? Scan the QR code and you'll get it. Or if you registered for the, let me go back. Sorry, if you and if you registered for the webinar on Livestorm, you will get the link in your email. You'll get a separate link. Okay, so scan this QR code, and you will get it. All right, guys. A little bit over 1 hour, but I think it was good material. So let's summarize everything that we discussed today. If you are Indian, if you were born in India, regardless of your citizenship, if you're on H-1B visa and you have your EB-2 approved anytime, I mean, better before 2020, but anytime is going to speed up your process anyways. And by now you know that you will be able to get your EB-1A approved if you work with my guys. And I'm talking about myself, okay? I'm not talking about other attorneys, this kind of craziness. I'm talking about my team and myself and my processes, my methodology, okay? My strategy, we're gonna get you approved for EB-1A. Okay, and if your priority date for EB-2 before September 2020, we're gonna get your green card end of 2024, the beginning of 2025, if you start working now. If your priority date, let's say 2020, 2021, 2022, I mean, it's gonna take maybe a year or two after the approval for EB-1 of EB-1A to get your green card. But again, it's much faster than 12 years. Okay, much faster. So guys, free evaluation. Okay, you're gonna get the links, and let me get you the QR codes if you didn't have time to scan them. Get the guide. If I send you the message after your free evaluation that you have the potential, come to the complex immigration planning, so I could build up the in-depth strategy, and then hire our services, sign the contract, 6 months, we're gonna get you approved, and you're gonna get your green card really, really fast. All right, guys, good webinar. Follow up on the insights from the recent conference from New Orleans. It was on business immigration. By the way, EB-2, EB-3, and H-1B visas were there too. So there are a bunch of insights over there. Yeah, follow up on that. And everybody have a good end of the week. I'm Stanislav Shamayev, a lawyer of the future. Your future begins here. Good luck.